evening and welcome to this, which is the fifth and final in our first series of remote family law seminars. I'm Sian Smith and I'm really pleased to be introducing our seminar this evening, which is Applying Criminal Law and Procedure to Police Evidence in Care Proceedings, the ABE interview. The discussion tonight is going to be between Gemma Farrington and Alison Pryor, who are both barristers at 42 Bedford Row. It will be about 35 minutes. We're not going to have any questions this evening, and we think all your questions will be answered by Gemma and Alison as they go along. But they have prepared a handout on the topics they're discussing, so you'll be able to access that via our Chamber's website very soon. And as always, the seminar will be available on our YouTube channel after today. So without any further ado, I'll hand over to Gemma and Alison. Thank you.
Welcome to our seminar today, where Alison Pryor and I are going to be discussing applying criminal procedure to police evidence in care proceedings, and specifically in respect of children's evidence and the ABE interview. I am Gemma Farrington, a barrister at 42 Bedford Row, and I practice exclusively in children's law with an emphasis on care proceedings. Alison Pryor is also a family law practitioner at 42 Bedford Row, and as well as practicing in all aspects of family law, she has a wealth of experience in criminal law. We decided to discuss this area, having been in a case together where there was a real focus on allegations the child had made, and where the ABE interview had been poorly undertaken. Alison used her knowledge in criminal law to seek disclosure of various documents and to cross-examine the officer in a skillful manner. And it struck me that there were areas of knowledge arising from a practice in crime that would prove extremely useful when approaching police evidence in family law. Today, we are focusing on and discussing children's evidence, and in particular, the ABE interview. We thought it would be useful to begin our discussion with a short potted history on the different approaches taken by criminal and family law to the question of children giving evidence. I'm going to hand over to Alison now, who is going to talk about the historical approach in criminal law.
Thank you, Gemma. Until the Youth Justice and Criminal Evidence Act of 1999 came into force, the view in England and Wales at least had been that children, and particularly very young children, were not reliable witnesses. In the case of Woolwalk, which was a 1958 Court of Appeal case, then Lord Chief Justice Goddard said this: the court deprecates the calling of a child of this age as a witness. The jury could not attach any value to the evidence of a child of 5. It is ridiculous to suppose that they could. Interestingly, though, in the second edition of a treatise on the law of evidence in Scotland, which was published in 1864, the Scottish advocate, Sheriff Depute and writer William Gillespie Dixon had observed that an intelligent child is generally a good witness in matters within his comprehension. Being accustomed to observe more than to reflect, he tells what he has seen or heard without drawing inference or preconceived opinion. In cross-examination, a young witness generally tells ingenuously whether he has been tutored, and if so, what he was desired to say. But in England and Wales, the contrary view continued to prevail, and in 1990, in the case of the Crown and Wright and Ormerod, the approach set out by Lord Chief Justice Goddard in Woolwalk was praised in the following terms: the validity of and good sense behind that proposition that child witnesses are not reliable has remained untrammeled in the practice of the criminal court. But the Youth Justice and Criminal Evidence Act turned this approach around, and now there is no special treatment for child witnesses, but just one question for the tribunal to ask itself: is the individual witness competent to give evidence? And what the Youth Justice and Criminal Evidence Act says about that at section 53 is that all persons are competent to give evidence regardless of their age, unless either it appears to the court that the witness cannot understand the questions put to him and give answers to them which can be understood. The question of competence of very young witnesses was considered by the Court of Appeal in the case of the Crown and Barker 2010 EWCA Crim 4, a case which will be as familiar to family practitioners as it is to criminal ones. This was an appeal against a conviction for rape of a child who at the time of the offence was not quite 3 years old. The trial came about because allegations the complainant, who was referred to throughout as X, had made to her foster carer. She was spoken to then by a police officer, but didn't repeat the allegations, and indeed appeared to deny that anything had happened. And in those circumstances, it was considered that it wouldn't be appropriate to conduct an ABE interview of the child. But months later, she repeated the allegations again, this time to experts in care proceedings, which had by then ensued. The decision not to conduct an ABE interview was reviewed and reversed, and the child made the allegations in some detail in the interview, and the defendant was ultimately charged with her rape. By the time the matter came to trial, she was 4.5 years old. Her ABE interview was to stand as her evidence in chief. But before deciding whether to admit it into evidence at the trial, the judge considered the issue of her competence, and he did this both by viewing the interview and by hearing expert evidence. Having gone through that process, the judge found that the complainant was competent and her evidence was admitted. At the trial, after her ABE interview had been played, the child was cross-examined and re-examined over a video link pursuant to special measures provisions in the Youth Justice and Criminal Evidence Act. At the conclusion of her evidence, the defence raised the issue of competence again, arguing that the complainant had not been able to understand the questions that had been put to her. The trial judge said this in his ruling on the issue. When simple questions were asked, the defence were able to put their cases sufficiently to ensure that the defendants have a fair trial. Inconsistencies or matters of credibility and reliability are not competence. The interpretation of silences go to credibility and reliability and not the witness's competence. The jury observed the complainant with care throughout and are capable, properly directed, of coming to their own conclusions. It may indeed be that this case concerns a child at the edge of competency, but having seen and heard her, although inevitably her intelligibility and therefore her ability to be understood were at times difficult, X did pass the test of understanding and intelligibility sufficient for me to say that she is and was a competent witness. The defendant was convicted and appealed on 2 grounds, one of which again was that the complainant was not competent, that the judge had fallen into error in making the assessment that he had. The Court of Appeal took the view that in reality what the appellant was arguing was that a conviction that was very heavily dependent on the evidence of a child aged 4.5, who was describing events that were said to have occurred when she wasn't yet 3 years old, could not be regarded as safe. The court rejected that argument and dismissed the appeal, and they said this at paragraph 38 of the judgment. Dealing with the issue broadly and fairly, provided the witness can understand the questions put to him and can also provide understandable answers, he or she is competent. If the witness cannot understand the questions or answers, or his answers to questions cannot themselves be understood, then he is not. The question is entirely witness or child specific. There are no presumptions or preconceptions. At paragraph 39, the court said that whenever the competency question is addressed, what's required is not the exercise of a discretion, but the making of a judgment, that is, whether the witness fulfills the statutory criteria. In short, it's not open to the judge to create or impose some additional but non-statutory criteria based on the approach of earlier generations to the evidence of small children. And although the chronological age of the child will inevitably help to inform the judicial decision about competency, in the end, it's a decision about the individual child and his or her competence to give evidence in the particular trial. And the court made a further interesting point at paragraph 42 of that judgment, finding that the competency test has not failed because the forensic techniques of the advocate, and in particular in relation to cross-examination, or the processes of the court, for example, in relation to what was described as the patient expenditure of time, have to be adapted to enable the child to give best evidence of which he or she is capable. And that issue, the impact of requiring advocates to adapt their cross-examination for child witnesses, was considered again by the Court of Appeal in the case of Edwards. This concerned a 5-year-old child who had alleged that the defendant had punched her in the stomach, causing quite serious injuries. Again, at that trial, the complainant gave her evidence during the video link. And during her cross-examination, the judge had interrupted defence counsel several times to invite him to pose open questions to the child rather than putting suggestions to her. The judge's concern with suggestions was that where the child agreed, it wasn't clear whether that was she was giving accurate evidence or just agreeing with counsel. The defendant was subsequently convicted, and he appealed on the grounds that the way the judge had restricted his cross-examination had made the complainant look more reliable than she was, and that the restriction had prevented him from testing her reliability, her consistency, and her credibility. But the Court of Appeal endorsed the approach that had been taken by the judge. They found that he had been right to seek to avoid a situation where defence counsel confronted the complainant, because that would have caused her confusion. They also said that it was difficult to see how the right to a fair trial had been compromised simply by the defendant's counsel being restricted from asking the complainant that the defendant didn't punch you, did he? I'd like to finish this section of our talk by very briefly referring to a case in which the child complainant wasn't required to give evidence. And this is a case of Riat 2012, EWCA Crim 1509. The child in this case was 3.5 years old. She had made a specific allegation to her mother shortly after the sexual assault was said to have occurred. The mother promptly called the police, who attended, but when they came, the complainant hid and wouldn't cooperate with them. In fact, her reaction was such that the police didn't see any point in even assessing whether an ABE interview with her would be possible. There was other evidence which was capable of supporting the allegation that the child had made to the mother, and the defendant was duly charged. At the trial, the prosecution applied to adduce the child's complaint to the mother using the hearsay provisions, and hearsay evidence not being automatically admissible in criminal proceedings in general. The prosecution application was successful, and the defendant was subsequently convicted. On appeal, it was argued that the evidence shouldn't have been admitted because no assessment of the ability of the child to be ABE interviewed had been carried out. The Court of Appeal dismissed the appeal, finding that the judge had been correct to conclude that the police officers had approached the question of whether the child should undergo an ABE interview responsibly and that he had reached a proper answer. The court said that on any view, the child was near the bottom of the age range in which an ABE interview might be achievable, and her very strong reaction to any examination or inquiry was a powerful reason not to trouble her further, and more inquiry of her risk being abusive. What these cases all illustrate is that in criminal proceedings, the expectation and the norm is that children will give evidence, and proceedings and the approach of advocates have to be adapted to enable them to do so. This is in contrast to the position in family proceedings, as Gemma is now going to discuss.
Well, one of the cases that Alison was talking about was Crown and Barker, which is from 2010. And we are all now familiar with REW, which is a case from the same year from the Supreme Court. And we're also all very familiar with REW hearings at which the court considers whether a child should give oral evidence and be cross-examined. And sometimes it's difficult to remember the time when we didn't regularly consider those issues and have REW hearings. The first case I'd like to talk about is the case of LM, a child by her guardian, 2007 EWCA Civ 9. And it was an appeal against a decision by the trial judge to direct that the subject child should give evidence by video link. And I remember it well because I was in fact junior counsel for the guardian in that case. And the guardian's position, very clear position, was that it was inappropriate for so young a child to give evidence and that it would be oppressive. This child was 10 years old. She had made allegations against her father, as had the mother. The mother had withdrawn the allegations, but the current position of the child was simply unknown. And the trial judge noted that if there were criminal proceedings, this child might be required to give evidence, notwithstanding her young age. He was also referred to the case of B and Torbay Council, the decision of Mr. Justice Coleridge from 21st of March 2006, in which Mr. Justice Coleridge made observations of needing to have the best evidence possible. That case was a discharge of a care order application, and the boy, aged 13, had made allegations of sexual abuse, and then at the age of 17 had retracted them. The evidence of that child had been received on video film and not tested at all in cross-examination. And Mr. Justice Coleridge commented that however good the procedures for the interviewing of children may be, they are never more than that is interviews. They are not evidence which has been tested in court. So having been referred to that case, the trial judge said, "It seems to me that the law as to the exercise of this discretion is moving on. If a child can be questioned in the court setting without damage to the child, which is oppressive, then normally, if they are of appropriate age, the child may be questioned. He considered that this 10-year-old was capable of understanding the need to tell the truth and of giving evidence, and he granted the application to have her called to give evidence by video link. Well, the case came before the Court of Appeal very quickly, and that approach, that normally a child will be required to give evidence if that can be done without damage amounting to oppression, was corrected. And Lady Justice Smith, at paragraph 44 of the LM case, said the following: the correct starting point is that it is undesirable that a child should have to give evidence in care proceedings, and that particular justification will be required before that course is taken. There will be some cases in which it will be right to make an order. In my view, they will be rare. And the Court of Appeal saw no reason to say that, in effect, the law had moved on. However, they exercised their discretion afresh. They decided it was an unusual case. The mother had retracted the allegations and nobody knew what the child said now. And the conclusion was that the judge's need for evidence must outweigh the concerns. So in fact, in that case, the 10-year-old child did give evidence. Has to be said, there were no proper procedures in place, there was no proper support mechanism in place, and there was, of course, no real guidance at that stage in respect of how to question a child witness. So then we come forward to Re-W in 2010, which really did herald a change in approach. And the starting point was that they looked at the approach stated in Ellen and Medway, and they said that insufficient weight to the convention rights of all concerned had been given. All parties are entitled to a fair hearing, and there should be no presumption that such cases will be rare. They went through the history of how criminal procedure in respect of children developed, and Lady Hell said, the presumption against child giving evidence which requires to be rebutted by anyone seeking to put questions to a child cannot be reconciled with the approach of the European Court of Human Rights, which always aims to strike a fair balance between competing convention rights. Article 6 requires proceedings to overall be fair, and this normally entails an opportunity to challenge the evidence presented by the other side. But even in criminal proceedings, account must be taken of the Article 8 rights of the perceived victim. Striking that balance in care proceedings may well mean that children should not be called to give evidence in the great majority of cases, but that is a result and not a presumption or even a starting point. And she went on, when the court is considering whether a particular child should be called as a witness, the court will have to weigh two considerations: the advantages that this will bring to the determination of the truth and the damage it may do to the welfare of this or any child. And we're all now familiar with the issues that the court has to consider. The quality of the evidence it already has, and of note, the quality of any ABE interview will also be an important factor. The nature of any challenge the party may wish to make, the age and maturity of the child, the length of time since the events in question, the risk of harm to the child, the support the child has from family and other sources, the child's own wishes and feelings, the views of the child's guardian, and the views of those with parental responsibility, and of course, the risk of further delay. The court also has to factor in steps that can be taken to improve the quality of the child's evidence, and at the same time to decrease the risk of harm to the child. At paragraph 27, Lady Hell noted, the whole premise of the achieving best evidence and special measures in criminal cases is that this would improve rather than diminish the quality of the evidence to the court. And there was discussion within UW of video cross-examination, cross-examination by video link, and putting required questions through an intermediary, all matters that we now discuss routinely when we're considering Re-W applications and Re-W hearings. The last case that I wanted to talk about in this section of our seminar is the case of Re-E, a child, 2016, EWCA CIV 473, another Court of Appeal case. And in this case, there is much said about the faults in the ABE process, and I will refer and have a look at that later on in the seminar. But the part that I want to refer to here is what Lord Justice McFarlane noted at paragraph 46, which is this: children who have made allegations that are subject to criminal proceedings are required to give live evidence within the criminal process. 40,000 do so during the course of each year. Conversely, for many years, the practice and culture in family proceedings was that such children, even if aged in their late teens, would never be required to give live evidence in the family court. He refers back to REW and quotes extensively in this case the paragraphs that I've already set out before. And he notes at paragraph 56, the previous culture and practice of family courts remains largely unchanged. And at paragraph 62, he says this: if the ABE interview process is poor and there is little or no other evidence, then it may be that no findings of fact in accordance with allegations made by a child can properly be made, unless the child is called to give evidence. The REW exercise must plainly take account of such a situation. So the very clear suggestion there is that we really must evaluate and investigate the ABE process even before the court considers the REW exercise. So I'm now going to hand over to Alison and ask her what we should be looking at and asking for when we are examining the quality and the procedure of the ABE interview.
Well, the starting point has to be compliance with the good practice, which is set out in the document Achieving Best Evidence in Criminal Proceedings. The document is advisory only rather than being a code of conduct, but it's made clear in the document itself that what's described as significant departures from the guidance can have consequences at any trial or contested hearing. And we're going to hear some more about that and how those have been treated in the case law in the last section of this seminar. The guidance divides the ABE process into three broad stages. The first is the preparation for the interview. The second is the interview itself. And the third stage is witness support during and after the interview and prior to and during any subsequent trial or contested hearing. The interview itself is then subdivided further into four stages, and I'm going to talk a little bit about what each of those four stages involves. Stage one is called the rapport stage. That is, as one might imagine, the part of the interview where the interviewer gets the witness comfortable. But it also includes some very important aspects of the ABE process. Those are setting the ground rules. So, for example, the witness knows what to do if they want to break, how many breaks there are going to be, and when, and also what to do if the witness doesn't understand the question. Very importantly as well, this is a section where the interviewer is expected to cover truth and lies. It's an absolutely essential part of the process for very obvious reasons. If a child at this stage shows no appreciation of the distinction between truth and lies, the guidance suggests that consideration needs to be given to instructing an expert assessment of the child's abilities, because a lack of understanding of truth and lies by the child during the interview may seriously jeopardise the evidential value of that interview at a later stage. So once the rapport section is over, and that will be as long or as short as the individual witness's needs really require, the next section, the next stage of the interview, stage two, is called the free narrative account. In this phase, the idea is that the interviewer initiates an uninterrupted free account of the incident or the event from the witness, and that's done by means of an open-ended invitation. The guidance says that in most cases, interviewers should initiate this account by just asking the witness to concentrate on the matter in issue or the incident that's the subject of the investigation. And it's really important that the witness is not interrupted during their narration by questions. Those questions should be kept for the next stage. To encourage the witness, the interviewer is supposed to use non-specific prompts, such as, did anything else happen? Is there any more you can tell me? And the guidance suggests that using words like tell and explain is likely to be the appropriate way to elicit the information. But again, very, very importantly, the prompts that are used at this stage should never include information which is known to the interviewer concerning relevant events, but which have not yet been communicated by the witness. That information has to come first from the witness, him or herself. Once a full free narrative account has been given, the interview moves on to stage three. That's the questioning stage. It's suggested that before the interviewer embarks on these more detailed questions, the witness is told that that's what's going to happen next, and told in some way that they would like to expound and clarify on what has been said. The guidance also suggests that it might be beneficial at this stage to reiterate some of the ground rules that have been outlined at the beginning, for example, to explain that details required, and importantly, perhaps particularly with child witnesses, that saying I don't know or I don't understand is perfectly acceptable. So in the questioning stage, the interviewer should divide the narrative account that's been provided into manageable topics. The topics should each be introduced by what's described as an appropriate technique, an open-ended invitation to the witness to focus on the particular subject matter of whichever topic is being dealt with in some detail. In terms of the types of questions that could be asked, the guidance covers the various different questions that can be used. And I'm just going to briefly explain some of the types of question because I think that can be quite helpful. So open-ended questions, such as those which are encouraged of in the free narrative account stage, they're frequently using the words tell and describe. So for example, you said you were in the shopping centre this morning when something happened. Tell me everything you can remember. Those are the preferred type of questions for the information gathering stage. The next best type of question, the guidance says, are specific closed questions. And these are the type of questions that it's suggested are used in the questioning phase of the interview to elicit information not provided by the witness in the free narrative account. An example of that would be, where were you sitting? When did he say that? So where, why, when, what questions are typically specific closed questions. The next type of question is what are described as forced choice questions. These are where the witness is only given a small number of alternatives from which to choose. For example, would you like tea or coffee? The difficulty with that is that they might not include the right option, which can leave the witness with very few places to go and can be confusing, particularly for child witnesses. The guidance is really clear that these types of forced choice questions should be avoided if at all possible and used only as a last resort. Multiple questions, where several questions are wrapped up in one, bring their own problems, chiefly because you won't always know which of the questions the witness is answering. And in fact, that was part of the problem that the appellant faced in the case of Barker, which was discussed earlier in this talk. But also multiple questions can be confusing and very difficult for young children to process. So those are to be avoided. And then finally, there are leading questions, which everyone will be familiar with. As the guidance makes clear, it's likely that where leading questions have been used, then if the interview is going to be submitted as evidence in criminal proceedings, then portions might be edited out, or in the worst case, the whole recording could be ruled inadmissible, and the effect can be equally serious in family proceedings. So after the questioning stage of the interview, where more detail about the account has been elicited from the witness, the interview moves on to the final stage, the closing stage. The first part of that is recapitulation. If appropriate, the guidance says interviewers should consider briefly summarising what the witness has said. They're encouraged to use the words and phrases that the witness themselves has used as far as possible, so that the witness can check the interviewer's recall for accuracy. The guidance says that the interviewer has to explicitly tell the witness that they can correct the interviewer if the interviewer has got anything wrong or has missed anything out. And the witness should also be told that if they want to add any new information at this stage, they can do, and it's okay to interrupt and to do so if they have something that they want to add. And finally, it's stressed it's really important to end the interview by making every effort to ensure the witness isn't distressed and is in a positive frame of mind. But no praise or congratulations for providing information should be given. It's a really important point. So that's the guidance as to how the interview itself should be carried out. But equally important is how the interview is prepared and planned. The guidance itself says that it's impossible or difficult to overstate the importance of the preparation stage and sets out very, very detailed guidance on what should be done in that preparation stage. The investigating team is expected to get some information about the child and their background first, And there are examples in the ABE guidance of the types of information that might be sought, for example, obvious things like age and language ability, but also information about how the child is at the time, their current emotional state, and any recent significant stresses that the child or the family have experienced, the sorts of things that the team investigating will want to take into account when planning how the ABE is going to be done. Consideration also needs to be given as to how to prepare the child for the interview, what to tell them and how about what the interview is and why it's being done, as well as considering how the interview is going to be conducted, what the ground rules will be, for example, how to approach truth and lies, the issue of breaks, how many and when, for example, who should be in the room with the child, if anybody, apart from the interviewer, and all the practical considerations like that. What's really important to bear in mind from the advocate's point of view is that the investigating team is supposed to keep a written record of this information gathering and planning process. Excuse me. And to record the decisions that have been made and the information and the rationale which underpins them. In criminal proceedings, this written record will either be disclosed as evidence or more likely be listed with all the other relevant documents that have been obtained or created by the police in the course of investigation, but which the prosecution doesn't intend to rely on as part of its case. And this list is called the MG6, or the Schedule of Unused Material. And that has to be provided, that list, has to be provided to the defence. But in family cases, in my experience at least, this planning and preparation document isn't routinely disclosed along with the ABE interview. And it may not therefore be obvious to practitioners that it exists, or at least it should exist. But it is worth getting hold of because it can be a really useful source of information in a number of ways. For example, it can contain evidence of conversations with the witness and or their family members or carers, which haven't been documented elsewhere. And that might give rise to questions that a party would like to ask about what was said during those conversations. The record can contain information about the witness which isn't recorded elsewhere, or which is recorded elsewhere, but in such a way that it's not clear whether the details were known before the ABE interview, or who provides the details, and that can sometimes be really important information for an advocate to have. And in addition, the document will inform you as to whether the interview was or wasn't well planned and well prepared. It can help assess the investigating team's approach to record keeping and their understanding of the ABE guidance. And as a result of that, you might want to consider asking the officers further questions about the investigative process, adherence to the guidelines, and the training and experience of the interviewing officers, and so on. Gemma's now going to talk about some cases where this guidance blatantly hasn't been followed, and that has had an impact on the whole case.
Thanks, Alison. Yes, we can see from case law that the quality of the ABE interview and whether it can be seen as reliable is often a key factor in whether findings of fact based on a child evidence are made. And the first case that I want to talk about is TW and the City Council, which is 2011 EWCA Civ 17, another Court of Appeal case. And that case reiterates the importance of thorough planning of ABE interviews and adhering to the guidance, both matters that Alison has talked about just now. It identifies that there are three pivotal documents when interviewing children. There's the guidance that we've been talking about, there's the Cleveland report, and there's the Pigott report. And it goes into helpful detail, particularly in paragraphs 22 to 30 of the judgment, about the guidance. And it reiterates that makes it absolutely clear that the interviewer has to keep an open mind, and that the object of the exercise is not simply to get the child to repeat on camera what he or she has said earlier to somebody. And in this case, on the face of the interview, there was an inadequate establishment of recall, absolutely no free narrative recall by the child, an abundance of leading questions, and no closure. Everything was led by the officer, and nothing introduced into the interview by the child. There were other matters relied upon in the appeal, but the court found that along with those matters, the trial judge accepting the validity of the child's interview was enough to set aside the finding of fact that the child had been abused. Another case, which I've already mentioned already, RE, is a case, again, Court of Appeal. I gave the citation earlier, It's 2016 EWCA Civ 473. It's a case that involves another inadequate ABE interview. It emphasises that the trial judge must analyse whether the flaws in the ABE exercise render the interviews unreliable. And in that case, found that the introduction of the truth and lies aspects of phase 1 were not undertaken on camera. No note of what transpired with the children in the police station during the hour that they were out of the interview room were provided. Children were seen at their home by the interviewing officer for a process of fast-track questioning, and the short summary note of what each child may have said during the fast-track process was wholly inadequate. There was no written record available at all from the police of the ABE process. Again, something that Alison has referred to, that the guidance establishes should be kept. The officer involved was not called to give evidence, so the court did not have an account of those matters from another source. And the questioning of the officers was on all fours with the earlier case that I just talked about, TW and a city council, and was a clear attempt to have the children repeat on camera what they may have said to their foster carer. And the last case is EFGHIJ, Care Proceedings. It's a High Court case, 2019, EWFC 75. And it's a case where the judgment is by Mr. Justice Kean. And this highlighted the continuing failure of ABE interviewers to adhere to guidance. The officer had not written down any planning or preparation notes. Further, the judge found that the role played by the officer in the lives of this family is hugely significant. It was plain from her oral evidence and police investigation log that she had given no consideration to the ABE guidance at any time during her involvement with the children. Rather, she breached most aspects of the guidance and have accepted good practice when interviewing children and young people. The judgment contains stinging criticism of the officer, who is named, and a selection of the breaches found by the judge were no planning or preparation prior to any interview with the boys, excessively lengthy ABE interviews, little or no use of open questions, and the boys were asked by their mother, not by the officer, to compile a timeline. Because this officer was victim-led and had to believe the boys' allegations, she saw nothing wrong or inappropriate in undertaking 6 interviews with a 15-year-old, 11 with a 12-year-old, and 6 with a 10-year-old. There was no evidence of undertaking the interviews with the boys or their father with an open mind. And she was found to have inappropriately praised the children, another matter that Alison referred to earlier when talking about the ABE guidance. The officer failed to seek the advice of superior officers and or their permission to undertake what's quoted as a manifestly excessive number of unjustifiably lengthy ABE interviews. Well, I hope that we've managed to give you an idea of why we consider it's clearly important that advocates for all parties are au fait with the guidance and aware of what they should be seeking disclosure of as if they were in a criminal trial. Because we think, firstly, it will assist the court in any re-W exercise, and secondly, it may well form part of questioning at any hearing where the quality and reliability of any ABE interview will need to be explored. Most of all, we hope you found this seminar interesting, and we hope that you'll continue to watch other seminars in this series produced by 42 Bedford Row. Thank you.
Fantastic, thank you. That was such an informative discussion, so thank you, Gemma and Alison, for that. And I'm sure it will stand us all in good stead when we're dealing with cases involving ABE interviews from now on. So thank you all for coming. It just remains for me to remind you that the accompanying handout will be available soon via the Chamber's website. And that you can re-watch, or your colleagues can watch this seminar on our YouTube channel after today. And so I'm afraid this is the last in this series of family law seminars from 42 Bedford Row. We hope you've enjoyed them. We will be returning in the autumn with season 2. And we have a number of topics agreed already so far, but watch our website for further topics. But so far, we will certainly be having seminars on the issue of vulnerable parents, on fabricated and induced illness. We'll have part 2 of our parental alienation seminar. we will have a further discussion arising out of the emotional harm talk on complex trauma and treatment. And we will be talking about business assets in financial remedy cases. So thank you all very much for coming, and I'll see you next time.